Hi, my name is Andrew Meinzer of Meinzer Law Firm. We take care of people all across California who are planning to ensure that things go as they want when they die or become unable to take care of themselves anymore. Accordingly, the information that I'm about to provide is based on current California law. It's general information and not specific legal advice. Today I'm going to talk with you a little bit more about the type of property of two people in a marriage or registered domestic partnership. This is the second video of a four-part video series. If you live in California, then you need to know about community property, quasi-community property, and separate property. That's true especially if you're married or in a registered domestic partnership. In the first video, we discussed community property. Here we'll pick up with quasi-community property and separate property. So quasi-community property are all assets acquired by either spouse during marriage while not living in California that would have been community property had the spouse who acquired the assets been domiciled in California at that time. Domiciled meaning living there as their primary residence. Community property and quasi-community property are treated exactly the same according to California law. And because of that, I'll primarily discuss only community property and separate property for the remainder of this video series, but please note that the discussion of community property below applies equally to quasi-community property too. There are two exceptions to the rule that all assets acquired by either spouse during marriage are either community property or quasi-community property. The first exception is that assets received by gift or inheritance are the separate property of the receiving spouse and not the community property of both spouses. Second, the income or assets generated by separate property assets also are the separate property of the spouse who owns that separate property asset. And that's true even if received during marriage while living in California. And the same applies to each registered domestic partner of a registered domestic partnership. Of course, the assets that each spouse or registered domestic partner had prior to the marriage or registered domestic partnership are the separate property of that spouse or registered domestic partner. In other words, as to a married couple living in California, the separate property are all assets acquired by either spouse prior to marriage, and two, all assets received by either spouse during the marriage by gift or inheritance, and three, the income or assets generated by the separate property. Everything else is either community property or quasi-community property. Each spouse or registered domestic partner has sole control over her separate property. Planning ahead for transfer of assets after your death can be very complicated. There are many factors to consider, including who you want to receive the assets. Also consider how easy you want to make things for your family after you die. If you don't do this correctly, then you may create confusion or even conflict among family members after your death. Hiring an attorney experienced with California transfers of assets after death is critical for obtaining the results that you need. In addition, the advice and guidance of an attorney experienced with transfers of assets at death is invaluable in these cases. At Meinzer Law Firm PC, we have over 20 years of experience helping clients with transfers of assets in California. Again, I'm Andrew Meinzer of Meinzer Law Firm. If you know that you need our help with estate planning and transfers of assets at death, or even if you just have a question, please contact us and let us take care of you.